to be individually charged. What makes Morelos distinguishable is in our case, there was no stopping, as in this was, and the statute says it requires a series of conduct, multiple acts. So especially the stalking, is the state really arguing that he stopped and then started to his detriment? If he stopped and then certainly he's not going to start again after potential release conditions. No, he kept doing it the whole time. He kept making videos because he believes allowed to, and this is not stalking. So this is one course of conduct. Now, that's for a jury to determine whether Mr. Myers is correct or not. The problem is with doing this twice, the state is going to tell the jury, oh, he acknowledged it, he stopped, and then he started again and did a separate crime. That's how they want to tell the story to a jury, that this was two separate crimes. It's not, even if the jury thinks it is a crime in the end. And furthermore, this one only had one act. If it requires a series of conduct, they're going to say stalking again. There's not a course of conduct again if you're going to start it over. If the state wants to start over, they don't have that series of conduct again. Same problem with harassment. And again, I think that's why I'm conceding that this does not apply to the first one for my harassment motion, because that was a separate act. In that case, and I'm not conceding it's harassment, we don't think it was, but there very clearly was a stopping point in the sense that there was a couple breaks. He didn't make any videos, but he may be upset over it, but then he did another act. There was a clear defining point where a separate act started again that could be considered another harassment, although again, that's a problem as we've already discussed. But for this, for the two at issue, these were back-to-back videos. It's the same exact act, making two videos about how upset Mr. Myers was and about that he's wrongfully charged and he had his legitimate purpose. We'd get to that at trial if the court permits, which is a problem, as I mentioned. But that is only one charge, Your Honor, not two. It didn't stop and end the next day. It was one harassment. Same with the stalking, same course of conduct. Please read the statute here. There was no stopping point. And that's the understand the difference, Your Honor, is we're not saying we stopped and start again. We're saying he never stopped. And honestly, he'd probably still be doing it because he thinks he's allowed to. And he may be right. Mr. Myers may be right. But he's now respecting the fact that the state has, saying what's going on. He's stopped, but not because he wants to, because he believes he's in the right to do so, Your Honor, if that makes sense.
Okay. Mr. Myers, what do you want to tell me?
About the stalking. I didn't make a video about Shannon Walker between October 21st and January 22nd. Why didn't I get 2 counts of stalking right there? That's months in between, not even 19 days. If they're going to say it started and stopped, well, it stopped October 21st, and then it didn't start again until January 22nd. That's a lot more than 19 days, so they could have hit me with a new 2 stalking counts right there too, but they didn't. They could have actually hit me with a new stalking count because I didn't contact her from September 12th to October 15th. That should be 2 stalkings. October 21st to January 22nd, that should be another count of stalking. January 22nd to February 22nd, new count of stalking. So I mean, how can 4 months go in between and it's 1 count, but 19 days and it's not 1 count?
We just want a fair trial, Your Honor, on the actual alleged act.
All right. I am going to deny the motion to dismiss the